Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I am going to give you the top 5 estate planning mistakes. Before I get into that, I want to give you my contact information so that you can reach out with any questions. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can follow me on social media and send me a direct message. I'm at Amanda Rocha Law. So, without further ado, what are the 5 top estate planning mistakes that I see made over and over again? First, very big mistake is not funding your trust. If you have a trust, your trust can be drafted and notarized and still not be effective. You have to actually transfer property into the name of the trust, which is known as funding your trust, in order for it to be effective. Otherwise, it's just a document that doesn't mean anything. Now, of course, there are a few exceptions, and I have gotten into those in prior podcasts and videos and on my blog, but just very quickly, the most common exception to that is if you are in the process of funding your trust and you pass away in the meantime. At that point, there sometimes is an exception for that, but generally that's about the only exception to not funding your trust. And going along with not funding your trust is funding your trust initially and then changing ownership. So maybe you funded it with your primary residence, sold that house, and then did not put your new residence into your trust as a funding as a funding instrument. Then your trust is no longer funded, so you need to fund it with something else. Next, number 2, top estate planning mistake that I see happening is forgetting to update your documents. So estate planning is not a one-time thing, or it shouldn't be. Perhaps you create a will and a trust when you are in your 20s, and then you get married and have children, and then your children grow up and have grandchildren, and you purchase homes and you sell things. Every time something big like that happens in your life, you need to update your estate plan. Otherwise, it's outdated and people can be left behind, or people can inherit things that you don't intend for them to inherit. And in addition to just inheritance, an estate plan also has documents that protect you if you become incapacitated. If those aren't updated, you won't have the proper healthcare power of attorney, somebody to make decisions on your behalf. You might not have a proper power of attorney, someone to make financial decisions on your behalf, or even have your current living will up to date, letting your medical care providers know what you want and what you don't want. The number 3 most common estate planning mistake that I see is improper execution or not signing your documents. So oftentimes this happens when you either do not hire a lawyer to help you do this, or your lawyer is very trusting of you getting everything done, and that's fine, but here's the deal. Just having the documents drawn up does not mean that they're finished. You have to have them properly notified, and you have notarized, and you have to have them properly witnessed, if that's a thing. And you need to sign them. And if they're not dated or signed incorrectly or executed incorrectly, let's say you drafted your own will and you wanted to do a handwritten will and it was improper, some of it was typed, or you forgot a date, then it doesn't matter at all. So it needs to be executed perfectly every time. There are no exceptions. And that is why it's so important that if you are going to do it on your own, you do something like go through my How to Draft Your Own Will course, because it's created by an attorney who gives you every detail of exactly what to do, or you actually hire an attorney to do it for you. Next is waiting too long to create an estate plan. So this is something I see actually all the time. People wait until their parent is mentally unable to create their own estate plan, and at which point you can't create something for someone else like that, or your spouse now has dementia. Unless you have a certain power of attorney over them, you wouldn't be able to create an estate plan on their behalf, and nobody else would either. Somebody has to have the mental capacity to do this on their own. So waiting too long doesn't serve anybody. Number 5, the last one, is not telling your beneficiaries about your intent. I cannot stress this enough, that if you have a will or a trust or both, you need to at least tell your beneficiaries that they are beneficiaries. And if you are going to leave someone out, it needs to be well known. If you are going to give people less than equal shares, it needs to be well known. If you are going to add people who maybe are not your children or spouse or somebody that isn't an obvious choice to put in your estate plan, you need to let people know, because sometimes what happens is your intended beneficiaries think that you made a mistake, or that you were not mentally capable of making that decision, or that someone coerced you into doing it, or there's a variety of reasons as to what they might think. The point is, the only way that they're going to respect your wishes is if you tell them that, and then you draft usually a letter of intent if there's something going on that isn't quite expected. So those are the top 5 estate planning mistakes that I constantly see. If you have any questions about estate planning, probate, or anything like that, please contact me. You can find me on my website at www.amandarochala.com. You can comment down below if this platform allows you to do that, or you can find me on social media at Amanda Rocha Law. Thank you.